Thank you for the introduction, Jordan. As she mentioned, I'm Twan Samaha, not Terry Mutchler. I'll be filling in, pitch hitting here. Because of this unique situation, I do need to disclose a couple conflicts of interest, and the best way, of course, to do that is through transparency. I was originally not to be moderating this panel, but David Barrett, who is on our panel, was my client. I was his attorney representing him in the very first successful lawsuit under the 2016 FOIA Improvement Act. And so David was a successful plaintiff in Barrett versus Central Intelligence Agency here in federal court in Philadelphia, and David will be speaking about that litigation. I should also probably disclose, though we didn't ultimately collaborate, that David McCraw and I, also from the New York Times, had talked together about some litigation against the Office of Legal Counsel within the Justice Department. So with those disclaimers having been made, keeping my academic nose clean, let's go forward here with our distinguished panel, and let's begin with David McCraw, who I'm delighted to have, our Deputy General Counsel of the New York Times. So David, at your request, I'll be noting 7 minutes, and I'll give you a 2 and 1 minute warning.
Thank you very much, and thanks everybody for coming out, and for the organizers. I guess I should try to explain the craziness of my position, which is that, as Susan Long and her colleagues at Track showed, the New York Times is some distant star outlying there in FOIA world, that in the 16-year period of the Bush and Obama presidencies, the New York Times filed 36 FOIA lawsuits, all by me, and the next mainstream media organization was at 8. We ended up filing more FOIA suits than the entire industry, as it turned out, over that period, which is either a sign that we're really special or really insane. So I'm going to try to explain why it happened that way and what I think of its use here. One thing that Professor Croca's research showed there, which I thought was interesting, was that there's a difference between requests and lawsuits, and the fact that mainstream media may not be filing lawsuits is not really indicative of how much FOIA use there is. There's a lot of requests being filed, as you saw from the Bloomberg slide. I think that was probably from their news site rather than commercial, but it's hard to tell with them. But in any event, for most reporters, the process, whether it's the request process or going to court, is too slow. It's too public. You want to get an exclusive. You're much better off working from leaks. You're much better off just talking to a public information officer, at least in the first instance, as opposed to litigating. And so that explains part of what's going on here. Part of it, of course, too, is some institutional constraints. The fact is, other than myself and the lawyers that Jason works with, most lawyers really don't like doing FOIA cases. I think they're great, but they lack the sex appeal of defending a libel suit or fending off a subpoena to a reporter. They're hard work. You have to be persistent to grind on. So I think there's a certain amount of professional reluctance. The second thing is the idea that a lot of media companies don't want to hire outside counsel and spend money to do FOIA, even though there is fee shifting if you succeed. And so what we have done is simply moved it all in-house, so we don't have to worry about that. The great thing about FOIA is that as an in-house lawyer, if I win, I get to pretend that I'm an outside lawyer and can charge the government at market rates. And I think of myself as a really, really high-powered, big-time, big firm lawyer when I am in that pose. And so, in the last 14 months, we have generated, in 3 cases, $220,000 in fees. That's just found money. We went out and hired somebody with that money, another lawyer. So there is I think most companies are a little reluctant to get there and take that risk, but my company fortunately has done that. Let me just very quickly highlight what I think are sort of the lessons that I've learned from doing these cases. And one is, much of the blame for what's wrong with FOIA, I think, lies at the feet of the courts. 50 years ago, Ralph Nader, the consumer advocate, wrote a piece called the Freedom from Information Act, just after FOIA was passed, and he went out and his group went out and researched, working terribly. Last year in the Yale Law Journal, I wrote an article about that article, is never, for those of you who are starting your legal career, parasitic behavior is always rewarded. And if somebody great has done something, just, hang on to it, which I did. So I wrote about the Nader article. And what was fascinating was the things that he thought were bureaucratic problems. The bureaucrats were delaying. The bureaucrats were using exemptions completely out of line with what Congress intended. That privacy was being treated as some sort of overarching goal that the government was supposed to protect rather than to actually balance with the public interest. All those things are now the law. Everything he saw as bad bureaucratic behavior has now been adopted by the courts and are the law of the land. Congress keeps amending. They keep trying to make the statute better, and the courts keep taking away from it. And so I find that very discouraging. When I was doing the article for Yale, law students being law students, and therefore annoying, kept saying like, in a good way, kept saying like, well, why is that? I'm going, I don't know why that is, But, I think in part of it is that there are so many cases, and FOIA have been brought by pro se's or incarcerated individuals. I think the court gets exasperated. I think it requires them to do some dull work sometimes to look at documents. They get exasperated. I think they've bought into the sympathy for the agencies, and I think that's unfortunate. The second thing I'd point out is that when I first started this, I brought FOIA cases in essentially tried to be sort of thinking about and conscious about why we're doing this. Two things. One is the information evergreen? Because it's going to take a long time. If that information is not going to be helpful, then in 6 months from now, a year from now, 18 months from now, we're not going to go after it. Or I thought I wanted to change the law, so I took cases where I thought that we could establish good law. Now we're not that discriminating, and because what I found was that the litigation becomes the way to move to the head of the FOIA line. I was on a panel at Harvard last year where a bunch of people who do these cases were talking about it. And our idea, it was like this bizarre litigation experience, because most litigators sit around and say, well, then I won that case, and then I won this case. We're all saying, and then we settled, and then we got that. Because a lot of times what we're doing is bringing the suit, government attorney comes in, the government attorney becomes kind of the concierge for FOIA. Is providing services, moves us to the front of the line. The $400 filing fee essentially gets us out of that long queue at the agency. We now have a court breathing down the neck of the AUSA. The USA is now breathing down the neck of the agency. We get the documents. We call it quits. That's not how it should work, but that's the truth of how it goes. The last thing I would just say is I think that one of the great frontiers here has been attacking Exemption 5, which is the deliberative process exemption, which takes out most of everything you'd ever want to see from the government, where they have said it's deliberative, it's advisory, and we have been fighting that fight over and over again. And I think it's the one place where we've made a little progress, but I think we need to make a whole lot more. I think that you're going to find that the instinct to secrecy is great in the agencies. The last thing I underscore and end with is that I was representing pro se a writer in a case that's called Flores versus CIA, which the Second Circuit wrote a great decision about, and we won the right to have the CIA do a further search to see where they had documents. And case came out, and I received an email from a professor who said, I was reading your case, and I don't know what you're talking about, which is not unusual. And, and they said, all those documents were released in 1974. The CIA had told us they were secret. They were actually in many of them were in the congressional record. That's just how that frustration goes.
Thank you, David. We'll move now from David McCraw to Jason Leopold.
Well, again, thanks for the invitation to be here today. And I'll introduce myself, Jason Leopold. I'm an investigative reporter at BuzzFeed News. I use the Freedom of Information Act a lot in order to pry loose documents, mainly, at least over the past 5 years, from highly secretive agencies like the CIA, the FBI, the NSA. I realize this is not a contest, but I have 41 lawsuits against the government. mostly filed as an individual requester. So
He pulled this out of me in front of Congress one day, and I stipulate.
Yeah, I believe Susan Long's list of the
Yeah,
top
yeah, okay.
FOIA disputants puts you at number 1.
and it's as David said, this is not the way it should be, and largely what I have found is that agencies are just reluctant to release records. If I could just take a step back and explain how FOIA became an incredibly powerful tool for me and why I use it the way I do. I think it was about 6 or 7 years ago, I had reported a story on, let's see, Air Force nuclear missile officers. The officers who actually are responsible for turning the key in the event if they're called upon to launch nuclear weapons. There was an ethics training that they were given. And this ethics training was amazing. And somebody that I knew obtained documents, and it was a PowerPoint presentation teaching or instructing these nuclear missile officers on the ethics and morals of launching nuclear weapons. And this ethics training contained pictures of Jesus on a horse holding a nuclear missile. And it showed that, it essentially explained that Jesus would launch a nuclear weapon if he was called upon to do so. And there also was a presentation in there from Wernher von Braun, who is considered the father of the modern day space program, but is also a former Nazi SS soldier. And these are the two moral and ethical, guiding lights for launching nuclear weapons. I looked at these documents, and I was just blown away by, frankly, what it said, and that this was an ethical course that was taught for 20 years. So I thought that this was a really great story, and I called the Air Force. I called some people and to get some comment, and they told me, yes, in fact, we've been doing this for 20 years. So I wrote the story, attached the documents, and was amazed by how it took off. It just, the story itself just, it was picked up around the world. In 24 hours, the Air Force suspended the training. And within a week, they ended it outright. And I just saw that the power of having documents and how powerful it was that the documents speak for itself. I didn't have any anonymous sources. There was no one speaking on background. The documents were the primary source material. So that really started for me this certainly a bit of an obsession on trying to gain access to government records. And as a national security reporter, we rely upon anonymous sources. And in this climate right now, obviously it's very, people are reluctant to immediately believe what anonymous sources are saying because everyone, has an agenda. So I found that by trying to gain access to these records, whether it's about the CIA's torture program, whether it's about Guantanamo and their force-feeding procedures, the FBI's documents on Occupy Wall Street, which, by the way, they originally told us that they had none until we sued them and they realized, oh yeah, we have several thousand records. One, for me as a reporter, what it did is that once I was able to get some of these documents declassified, it made, or it helped me gain access to individuals who felt a bit more comfortable speaking on the record. And what has happened, however, is in the course of litigation, the government sees me as a nuisance. They've called me a FOIA terrorist, and that's actually what the FBI has referred to me as. As recently as a few months ago, the NSA, in an extraordinary Open America filing in court, says I have weaponized FOIA and essentially is using it to try to take down the government. that my news organization, BuzzFeed News, hired me to essentially deluge the government with FOIA requests. They simply saw it as I am trying to get to ahead of the line. Ultimately, we prevailed against the NSA and forced them now to release all their FOIA stats every month in regards to this lawsuit. But it's just been incredibly difficult, still difficult right now, to try to gain access to these records. And like David, I go to court oftentimes to get to the top of the pile, to get records released in order to provide the public, provide all of you with timely information about what's taking place behind the scenes.
We'll now move, thank you, Jason, very interesting. We're going to move now to David Barrett, our own colleague in the Department of Political Science.
Thank you, Tuan, and I'm delighted to be here with Jason and David and all of you. So, again, my name is David Barrett. I'm a member of the political science faculty at Villanova University. So I'm a political scientist by training, but really I'm a historian. I do presidents, Congress, wars, the CIA, national security, the Vietnam War, and President Johnson is a real topic of mine. To the extent that I've had success as a scholar, it's because I'm really into archival research. That's what I do. I go and I think I'm pretty good at it. My success is not based particularly on lawsuits. So you've done dozens of these lawsuits. I've done one. I do like the name of the lawsuit. It's David Barrett versus the CIA. I take great satisfaction in that name. And my friends, when with Tuan, the lawsuit was filed, I love being kidded by my friends that, well, watch out for those strange cars that are creeping through your neighborhood and weird the sounds on my cell phone. So, most of you know what Bay of Pigs was. In 1961, President Kennedy authorized the CIA to do what was supposed to be a secret intervention in Cuba to overthrow the government of Fidel Castro. Planning for this event had been seriously underway in the last year, especially of the Eisenhower presidency. The event failed spectacularly. It was a covert action that wasn't very covert. The New York Times had some reporting on it in advance of the event. Other journalists had even more. It wasn't very covert. It failed. CIA basically used Cuban exiles to go in to try to overthrow Castro. Some, I think dozens died. Hundreds were imprisoned in Castro's. They were imprisoned in his prisons. So a big event, and then the huge, Kennedy himself privately said, how could I have been so stupid? Publicly, he took responsibility for the failure. There was a lot of finger pointing in the aftermath of Bay of Pigs. The last thing Kennedy wanted was to be blamed too much for this event. There was a lot of leaking going on. CIA is to blame, the military is to blame, the State Department is to blame. Well, anyway, in the 1970s and 80s, a CIA staff historian named Jack Pfeiffer took on the task of writing a 5-volume history of Bay of Pigs. Federal government agencies, I didn't know this till about a decade ago, I guess all federal government agencies have staff historians who write histories of what those agencies do. So Pfeiffer was at the CIA. Now, the thing about these histories is at CIA and NSA and some other places, I'm sure, well, after they're written, they're then stamped top secret. So, and they're just sort of put away. By the time Pfeiffer had completed his work, and now we're into the sort of early 80s, he wanted to have these things declassified. He actually went to court to get the declassification of the very volumes he had written. Of these 5 volumes, one deals with transition period, Eisenhower to Kennedy. That's, strangely enough, labeled Volume 3. There are 3 other volumes that are a couple of volumes that are more about the event itself, and then a couple of the volumes, including Volume 5, subject of our lawsuit, which are really about Pfeiffer's analysis of other groups' analyses of Bay of Pigs and who was to blame and all that. So this was a fiercely fought over question. Pfeiffer was unsuccessful in getting the histories he had written declassified. Across the decades, National Security Archive, affiliated with George Washington University, pursued through Freedom of Information Act and eventually lawsuits the declassification of these volumes. It turns out, because of the JFK Assassination Records Collection Act, one of the volumes actually was declassified by the CIA. They put it in the National Archives, and they didn't tell anybody it was there. I was doing research. There were a couple hundred boxes. I forget how many hundreds of boxes in the JFK Assassination Records collection, but I went through them all, and one box was marked CIA Miscellaneous. I opened it up, and here's this like 350-page history, this volume 3, transition period, Eisenhower into very early Kennedy. And I had a book that was just about to come out in a couple of months called The CIA in Congress, from Truman to Kennedy, up through Bay of Pigs. And I was so annoyed at myself that I didn't know this declassified history even existed. And then I realized, I thought about it, and I thought, well, yeah, but I've never seen anyone cite it. It finally occurred to me, nobody knows some people knew it existed, but no one knew that it was declassified. So I was able to I couldn't use it in my book, a bit frustrating, but I was able to publicize it. Some newspapers wrote about it. So National Security Archive pursued the declassification of the other volumes. They succeeded in getting 3 of the other 4 declassified. Volume 5 is the one that CIA was hanging on to through FOIA, through lawsuit. Actually, National Security Archive sued about that Volume 5, had success at the district court level, but lost, I believe this is correct, at the circuit court level. So CIA was prevailing. Oh gosh, 2 minutes. What can I say? No way, I'm sorry.
Okay.
Give me 4 or 5. As best I could understand CIA's position, they were claiming this was a draft volume. Pfeiffer had not quite finished it. Historians working for government agencies would experience a chilling effect if they knew that some draft history they wrote was later made available. And there's the whole Section 5 deliberative process, which I won't go into. Well, anyway, so along the way, I met Tuan Samahan. Now, I'm not a person who sues people. I've never had a lawyer in my life. I've never sued anyone. I've never really thought about even suing anyone. Never. But, you know, Tuan and I talk about these things, and he tells me that, you know, there's a potential for Congress to pass a new law, which President Obama would likely sign, amending the FOIA law. And so we made plans. Let's see, in 2014, along the way, I filed a FOIA request that was rejected. 2015, I requested a clarification of CIA's denial. I requested an administrative appeal. CIA deemed that a new FOIA request, which I think meant the cancellation of the old request. Anyway, so Tuan had a strategy that after the new law was passed and signed, we would file a new FOIA request, which we did. CIA rejected that. Let's see, they cited what they said was a still pending previous FOIA's request.
No, they canceled it, is what they told us.
Canceled.
We're
Thank you.
canceling it. We don't like it. We're canceling it.
So we
What
went
did the CIA?
so we went to court, Philadelphia federal court. As I've told you, so we did that. After a month or so, it became clear that the CIA was going to make the document available. We would settle out of court. They said, now this is the thing that irks me, they said in writing, we're going to do this because of Barrett's FOIA request and the lawsuit. So some weeks go by, they did make it available. I'll give them credit. They made available, you can find it online, with very, very few redactions. But they said nothing about the lawsuit. Now, meanwhile, we're also pursuing a reimbursement of the legal costs. The CIA did not want to pay the legal costs. They say in writing, I'll just sort of quote, the federal judge sort of summarizes what the CIA argues. The CIA argued that the plaintiff, I'm quoting the judge, that's me, the plaintiff did not confer a public benefit because his actions did not result in the release of Volume 5. And the CIA argues that the CIA had a reasonable basis for withholding the requested record. The court disagrees, unquote. That's the sentence I like. The court disagrees. Thank you, Judge Cynthia Ruth, who, by the way, is an appointee of President George W. Bush. So we did get the document. We got substantial court cost from them. So in some ways, this is a success, and I am within a minute of being done, I promise. So is this a success? Well, you could say, sure. But again, I'm not a person who sues people. I haven't really had an attorney. I've gone through life not having a lawyer. I find it depressing. I mean, and I've listened to what you two have said. I mean, it takes going to court to get these things. You know, most people don't do that. I mean, you know, BuzzFeed and the New York Times, I mean, great that you're doing that, but most sort of regular people don't do that. And I've heard from a panelist who will speak later today that FOIA has been very successful in a lot of ways, especially because of domestic policy results. But I'll just give you the sentence, that one last sentence that I wrote for a brief article I wrote about this lawsuit. It reads, very sadly, I have concluded that if you want to get the CIA to declassify something that it wishes to keep secret, get a lawyer. Thank you.
Thank you, David. So now we're going to move to our discussion on our panel, and then we'll open this up later then to questions. So the first question I have for our journalists on the panel is, you're the favored class of requesters, really. The Freedom of Information Act, as Margaret put it, was perhaps written by journalists and also was for the benefit of journalists. However, we know that the reality of the Freedom of Information Act is that both under requests and the subsequent litigation, you're going to experience enormous delay, which may limit its utility for a business that is driven by timetables, deadlines, and the press cycle. So what sort of recommendations might you have, given years now of experience with the Freedom of Information Act? What could be done to sort of change this? Do we need some sort of prioritization in the statute, some sort of front of the line relative to other types of civil litigation? Do we need to have a FOIA court?
Go for it, Jason.
Probably yes, and yes. But the reality is that, you know, journalists are not treated any differently than anyone else. I mean, this is, except when it comes to fees, you know, because we're serving the public interest. We can ask for a waiver of fees. But I think there are several things when it comes to journalists filing FOIAs and trying to inform the public. One, the requests should be written well in order to get a timely release of records. I mean, depending on the agency, you should really perfect your request. Understand system of record, where these records are located. If you file a request with the State Department, for example, the State Department is a massive, massive bureaucracy with offices all over the world, and if you're going to file it to, you know, the office of the secretary and say you want things on Russia, for example, well, perhaps that may go to the, you know, Bureau of Near Eastern European Affairs or Eurasia Bureau of Intelligence and Research. So it's really important for the requester to understand how the agency works, where records are stored, because that could actually result, you could end up saving months and months by perfecting the request. Know what to essentially ask for. The other thing that that can be done, and it depends on the agency. Certainly with the intelligence agencies, the NSA, the CIA, Defense Intelligence Agency. I mean, I hate to say it, but if I'm looking for a document out of the CIA, I'm not waiting for the CIA to get around to it. I'm filing my request and suing after 20 days. Because the reality is that they are not unless you somehow miraculously end up in what they call the simple queue. They have 3 different queues: simple, complex, and I think there's a medium. I've never been in either, other than the complex queue, no matter what the request is or how well I know how the system works. So it's just, this is the backlog. They have a backlog right now. I will note that a couple of days ago, I was floored by this letter that Secretary Tillerson, I'm going to say apparently wrote, because it's, I haven't confirmed it yet, but it's a letter on FOIA. And he essentially said that, you know, the State Department has 13,000 outstanding FOIA requests, and that they're hiring additional staff, and they're going to try to push through, you know, these records as quickly as they can. And if anyone has any questions or suggestions, send an email to foiasurge@state.gov. That's actually what the letter says. So, you know, there's two things. One, it's really important for the requester right now to understand how backlogged the agencies are, how difficult it is to still get records, despite the passage of the amendments last year. And with that noted, try to see what you could do to help, you know, speed up that process.
Yeah, and Jason hit all the points that I would as well. He's absolutely right. But let me just make 3 points quickly. If the courts put real pressure on the agencies, it would have a great change. You know, especially about delay. Delay is the #1 problem with FOIA. One of the first FOIA cases I did dealt with the Department of Labor and access to their this database they have of 13,000, the 13,000 worst place to work if you don't want to get killed at work. And they would release the list of the names, but they wouldn't release who was first and who was 13,000. So we sued over that. They came back, the agency had come, before we sued, we'd put in a request, and the agency came back and said that it would take roughly 11 and a half years to review the data and decide whether it could be released. And, you know, we are the failing New York Times. I wasn't sure we were going to be around that long. So I thought that was kind of preposterous. And the judge, you know, just said, he pulls out FOIA during our first conference and says, it says 20 working days here. I can understand if you said maybe it's going to take 40, but, you know, really it's going to take years? So if there were more judges who were willing to kind of put that kind of pressure on, I think it would change. Second thing is that, as Jason said, and this is one of those things that he's a master of and what makes him so good at this and wish others had, is that when I do a presentation for reporters, I always say it's not a vending machine. You don't put in your FOIA request and the thing falls out. It's like the vending machines of the New York Times. You have to shake them, it takes your money, you have to do all this kind of, you know, and the people who are really good at it, and David Barstow, who's an investigative reporter at the Times and won the Pulitzer Prize multiple times, you know, I was working with David on one of these for the Department of Defense, and I said, well, you know, David, I don't think we're going to get a response soon. He goes, what? He says, well, Judy's sick. Who's Judy? Judy's the FOIA officer. He's on the phone with Judy every day. He knows how her kids are doing in school, when she's on vacation. He treats it like reporting. He is cajoling, he is threatening, he is charming, he's doing all that stuff. It's just reporting. It's just a tool of reporting. Same thing you would do if you're working a source, same with FOIA officers. The final thing I'd say is that many of the FOIA officers I meet privately are really well-meaning and well-intentioned. They need to be set free. You know, they get locked in. They can only, if they release something inadvertently, they're in trouble. So the instinct is not to do that because they don't really have power within the organization. The example I would use is there's a case, I think it's called Taylor versus NSA out of Georgia, where a guy wrote in and said he wanted all documents pertaining to the implant of electronic monitors in his brain by the NSA. The NSA responded by saying, we can neither confirm nor deny we have any documents. The guy is paranoid. Well, why are you doing this to him? Why don't you just say, we don't have them? But, you know, the book is, we do not reveal our surveillance techniques.
Love it.
Maybe he's not paranoid.
And I know where he is right now.
Well, so now, speaking to our distinguished panel, and especially the press representatives here, you know, you've made it. So at one point in time, Jason, it must have been very difficult to find pro bono counsel, but now I'm sure you've got many a lawyer willing to line up to represent the great Jason Leopold. And of course, David McCraw has got, you know, he the best thing that ever happened to the New York Times, as far as I can tell, was the election of Donald Trump. And so you're going to have a lot more supporters and subscribers and more resources. But what was it like at the beginning, Jason, when you tried to find pro bono counsel? How hard or easy is it? Because this is sort of an access to justice
Sure.
issue.
It was very difficult because what I noticed was when I would read lawsuits, when I read FOIA lawsuits, that it's not the majority, but there were many people who were filing as individual, whether they were filing as individual reporters or even some news organizations that hired outside counsel. They would hire big firms like Jones Day, for example, or I don't know, any other big
Ropes and
firm.
Gray, right?
Yeah, where the attorneys were not necessarily specialized in the Freedom of Information Act. So it didn't mean, it didn't mean if you spent lots and lots of money with a big firm that it automatically scared the government and suddenly you'd see a large volume of records released. And in some cases I saw that very little was released. So I tried to find attorneys who specialized in FOIA, and that was difficult because there were very few who did so. But I was very fortunate. I found a lawyer that I've been working with for about 7 or 8 years now. His name is Jeffrey Light in DC, and in fact, I think on the track list, he may represent like a third of all the lawsuits that are on there. But it was difficult, and it was interesting over the years, as and this goes for certainly Charlie Savage at the New York Times and many of the other great reporters there, as others in the news media started to see the success that reporters would have with freeing up records, and famously the drone memo case that the New York Times had, and some of the Guantanamo things that or documents that I was able to release. I think that it opened it up. More and more news organizations wanted to get involved in it. Reporters wanted to get involved, and so attorneys who did specialize stepped up, and they were being accessed quite a bit more. So it was very difficult, and now I see many people sort of offering up pro bono work. There's an attorney in DC who specializes in national security work. After this administration came into office, he sent out a tweet: "Journalists, come to me with your FOIAs, and I'll sue pro bono." That wasn't happening 7 years ago. So it's just a different time now.
So now, we've been talking mostly about the high-profile and maybe somewhat sensational documents, and there is a whole body of work out there, which is sort of the quotidian slaving of the federal government, and there's a sense in which when something begins to bleed somewhere, that it draws more attention. So the press, the journalists, your sharks, and that's what you go to. But it may be the case that there are other stories yet to be discovered. So I don't recall many stories about these exotic financial instruments prior to 2008, which would lead to the end of the financial world there. Is there a sense in which, let me put this a different way. How do your journalists get the idea that a particular agency would have records that they should care about? There's a certain theory-ladenness to these requests. It's not an affirmative system of disclosure.
Yeah, and you're right that there are these sexier cases which people are attracted to. And it's one of the things that I fight internally is that we, for instance, I think there were 23 Hillary Clinton emails cases. I think there were 23 FOIA cases about Hillary Clinton emails. We weren't on any of those. And people are saying, well, why aren't we in this? And I'm saying, well, because if they win, everybody's going to get them. That's how it works. Release to one, release to all. Why don't we focus on the stuff that people aren't doing, so we're using our resources wisely? So that's what we've attempted to do. But you're absolutely right, Tuan, that one of the things that I look for is what kind of reporting has the person done? what has the person really done to get at this document? And through sources, through public information, through all of that sort of stuff, if you come on behind that, then, as Jason was saying, the focus request is going to work. I'll give you the example. We're seeking the documents on the chemical weapons that were found in Iraq after the war. U.S. personnel were sent out to clean up the old Saddam Hussein munition dumps. There were chemical weapons in there, crude, but people were getting gassed, people were getting injured from coming across them. And that was all classified. Our reporter, Chris Shivers, the great war correspondent, he said, request these documents, and he named 3 classified documents by name, which we requested. And of course, the government had to respond. They don't, we refused to confirm or deny those documents, even though it was obvious that we had seen them. That puts them in a very awkward position going forward, and we're able to also, in that case, show how many disclosures there were around that. We found every possible public reference to these documents, or at least the subject matter of the documents. Ultimately won that case after it became clear we were going to win on summary judgment. But a lot of that is just having the reporter partner with us to do the homework on these things. What do you know about the documents? Where are they? What's been said publicly? If you can get those things, you're going to have a very powerful FOIA argument.
Can I just add also, just on the note of getting ideas, in November of 2014, it became clear to me that Hillary Clinton was going to be was going to run for president on the Democratic ticket. And at that time, I put in a FOIA request. I actually don't know why, but I know I said to my editor, I think Hillary Clinton's going to run, clearly she's going to run for president. Why don't we ask for all of her emails? And I put in that request. And what I wanted to do with that was simply inform the public about, here's the nation's top diplomat, how this person would serve as, what a Clinton presidency may look like based on, these communications. That was just an idea, knowing that we would have a steady stream of stories throughout, the campaign. And we sued in January of 2015 without having any idea that 2 months later, the New York Times would break a story about Hillary Clinton had a private email server. And so, the lawsuit that I filed became the vehicle by which to release all of those emails monthly, to the detriment of Hillary Clinton. But unfortunately, the idea of these news stories just, it just never happened the way that I envisioned, because the scandal itself about the server took over. So, because the volume of emails that were released were very informative. But also on, getting to a point that David made about the classified disclosures. I had filed, requests for years and years with the CIA about arming Syrian rebels. Okay, this was a top secret program that clearly President Obama discussed many, many times, and the CIA continued to, issue me a glomar saying that they can neither confirm nor deny it, and that comments that Obama made were not specific as to the actual program. But Donald Trump tweeted about this program recently and essentially declassified it. Or at least that's the argument I made yesterday when I sued the CIA for...
This is what you filed yesterday,
yes,
correct? Right.
For all those, for all those records. That's, what we're arguing is an official disclosure, and he's an original classification authority. And yes, there you go. So hopefully we'll get those records.
Yeah, it does really show where we've been, because I have the same suit in New York that Jason has over the tweet. And so we actually had our preliminary conference with the judge, and it was one of the few times I've seen the lawyer for the government, the lawyer for the Times, and the lawyer for the judge, all trying not to laugh. Because the argument made is that the New York Times doesn't understand the syntax of Trump's tweet, that he's not really saying what he is saying. And I have to stipulate to that. I'm an officer of the court. I can't lie. I do not understand his syntax, but I have to agree with Jason. He's declassifying that program by tweet.
A Fifi here. Or something.
Right. And it's such a change from, because I've been in these cases where there have been what we consider either official acknowledgement of various documents. And usually you're doing deep dives into archives and congressional records and so forth. The idea that we're now going to be talking about 140 characters as official acknowledgement is really delicious.
Oh, yeah. Yeah, excited about it.
So maybe we could turn for a moment now to talk a little bit about some of the abuses that you have experienced at the hands of agencies, both with exemptions and other dirty tricks. So we've mentioned one of them already, which was the idea of trying to use a non-governmental email server as a way to circumvent searches so that the FOIA officer will come back, no such records. David Barrett, can you tell us what were the indicia that draft volume 5 was actually a draft? So they originally said, this is deliberative process materials. How obvious, looking at the document, was it that this was just a draft, as was claimed? So it was deliberative process, right?
It's not a draft. It's just not. I mean, again, you can look at it online. It's this couple 100-page. That one volume, couple 100-page history, it seems to me carefully footnoted as to sources. I know what bad writing, rough writing, I know what an unfinished draft looks like. I'm trying to finish a chapter right now. If I sent it to you, you'd see, it's badly written, it's a rough draft. I know what they look like. This looks, and I thought, well, I should see if anyone else addressed that question, and I literally did it this morning. John Prados, who's with National Security Archive, spoke to that very thing. He said he read it, and he quotes, and again, this can be found online, he quotes the CIA, the current chief historian at CIA, in whom I'm very disappointed for, even as the thing, after we succeeded, he said, well, it's bad scholarship, it's not really finished, it's what's the word for, it's too sort of fighting in its whole tone, but that doesn't make it it's not an unfinished draft. It's just not. It's not.
But that was what was represented, of course, to a court, that
Yes.
this could be withheld under Exemption 5. I'll take the opportunity as a moderator to mention here that in a case that my students, former students from Villanova litigated on my behalf, Samahan versus FBI here in federal court in Philadelphia. This was for a discussion between a sitting Supreme Court justice and a high-ranking FBI official about a case concerning the FBI and the FBI's practices. The discussion was ex parte. It was by a justice that should have been recused from the case, and the Supreme Court justice was disclosing the resolution of the case and the probable timeline in which the case would be disclosed. And so what I wanted to know was the rest of the story, and the rest of the story would have required my knowing something about some redacted information, which was asserted under personal privacy. And so as it turns out, this assertion of personal privacy was, on the one hand, what it effectively was that there was skullduggery by the J. Edgar Hoover's FBI, in which they were trying to research someone for the purpose of destroying them. But then, when it came time for me to request the record, they said, it would constitute an unwarranted invasion of personal privacy for us to give you the document where we were invading unwarrantedly his personal privacy. This sounds a little bit like John Oliver, but that was sort of an assertion of the personal privacy exemption. Can you tell me what are the worst sort of violations you've seen of FOIA by agencies? And if you could maybe name who are the, we can name names here, right? Who are not agency names, you
Yeah.
know, but in terms of agencies that are the most difficult in regard to the searches. Marcy, we'll give you your turn. You can speak up in defense of your clients here.
Well, you know, in part we're driven by where are those FOIA requests go. Obviously, these security agencies are rolling out, claiming everything's classified, whether it needs to be or not. I find that the FBI is particularly difficult and erratic at the same time. We had we did a FOIA request and a FOIA lawsuit over the documents from the FBI concerning the underwear bomber. Remember Abdul Muttalib, who's flying into Detroit and trying to blow up the airplane, instead gets his underwear on fire and is now in federal prison forever. We wanted those documents, and if you read our brief in that case, it's just this incredible misleading that we're going to get the documents, No, we can't yet. Then we file appeal, we win the appeal, it goes back, they come up with new exemptions and so forth. So, and then they finally released a document. They released a series of documents. There was one that I use in my PowerPoint which shows they have redacted the entire page except for the word propaganda, which I think was like performance art, or self-referential, deconstructionism, whatever. And we ultimately won the release of almost all the rest of that page. Completely unacceptable stuff about Abdul Muttalib growing up, how he came to meet people and so forth. And it's frustrating. The other one I'd use is in the case I mentioned earlier, Flores versus CIA, where Sergio Flores is trying to find documents about his father, who was the first and last ambassador from Cuba for the Fidel Castro government before he was thrown out of the country. Is that the CIA gave us a GLOMAR response. Can't confirm or deny. We were working with the Yale Law School FOIA clinic, and they went to the FOIA reading room, and the documents were there. And some of the documents were there. You know, they hadn't even bothered to even begin to search.
Jason, you shared with us yesterday
Yeah.
at dinner maybe some of the tactics that were used by one agency in particular. I'm thinking FBI.
Yeah, I can't ever not say, or that thing come out right. I can't say enough bad things about the FBI. And the way that they respond to FOIA, the way
They feel the same way about you, Jason.
Yeah. Oh, no, I know they do. And the way that they simply really just try to thwart the release of records. And they come up with new and novel ways each and every time. And I will name names. There's, you know, the head of the records information division there, David Hardy, who's been there for quite some time. He's largely the one responsible for coming up with new and different ways to deny requests. The newest one, and this started actually of the hundreds and hundreds of requests I have at the FBI, this was the first time I ever saw this, and this was crazy. This was last September. We had asked the FBI for certain documents about whether they had any documents about Donald Trump's comments regarding Second Amendment people. I don't know if anyone recalls that on the campaign trail. Without getting into it, you can certainly Google it. But and then another one where he asked for, you know, Russia, if you're listening, maybe can help get those 30,000 missing Hillary Clinton emails. And so we filed a request to see if the FBI had any documents about that. And the FBI issued us a GLOMAR, which I've never really seen a GLOMAR from the FBI. You know, they'll either say we don't have anything, it's part of an active investigation, but this was a GLOMAR, and on top of it, you know, a couple of FOIA exemptions to go along with the GLOMAR. So it was essentially the FBI saying that, yeah, we're not, at least the way I interpreted it at the time is, we're not, we're more or less exempt from FOIA. The way that the NSA and has the NSA Act and the CIA Act. But as I started filing more and more requests after this, that's the response the FBI has been giving, is that that we can't confirm or deny we have any records. I asked for records recently on Kaspersky Labs, which is this firm that cyber type firm that the government's been doing business with, and it's been in the news quite a bit lately, and the FBI said, yeah, we can't confirm or deny that we've ever communicated with this firm. And then they threw in B1 and B3 exemption to go along with it, to like really lock it down. And so that, to me, represents a new policy and practice, okay, in which the FBI is not just denying records, but anything that smells of Russia, it could even be borscht or something, you know, it's just completely, which I'm not saying it's Russian, but it's just completely exempt. Everything is you know, that they are withholding.
Well, now this can go to, I'm sorry.
Yeah,
go ahead.
I'm sorry, I just to put a point on that is that I go back, I think many of the FOIA officers are really, really dedicated civil servants locked into really terrible jobs without enough resources. One of the things that's interesting, and Professor Croca's presentation got at this, is that those agencies that have a lot of corporate requesters are actually pretty good. I was at a similar conference at Columbia, and this FOIA officer came up to me and said, oh, you know, nice to meet you in person. I didn't recognize him at all. So while he was speaking, I got out my phone and searched, and he'd written me 23 emails about a request. I didn't remember this at all. And then I saw what agency he is. He's with Food and Drug Administration. You know, they're used to demanding lawyers and demanding corporate requesters and so forth, and they have a pretty good unit. But if you look at the state units, states have powerful freedom of information laws like Florida, it can be done. It can be done. There are many states. Florida's backtracked a little bit, but Florida in particular, many states are just first rate at figuring out how to be transparent and have a government. Part of that is that in Florida, the move was fueled not by liberals, but by conservatives. They knew that you had to have a transparent government or those guys are going to steal your money, okay? And that coalition between liberals and conservatives really drove a first-rate Public Records Act in Florida. To tell you how far it got along, we actually at one point got into a fight over whether whether an official at a government agency had the right to open his mail before we saw it. Our reporter was there and saying they won't give me this letter, and they're saying, well, because he's out of the office for lunch and you'd like to open the letter before it's given to you. We finally relented. We thought that was probably too extreme. But that was kind of the whole ethos in the agency was, you got to turn stuff over. That's just how it works.
So I think most requesters will observe they've had the experience where there is a document and there are probable duplicates of that document, and you'll request it from one agency and get it redacted one way, request it from another agency and get it entirely withheld. And I've certainly found that some agencies are friendlier and more helpful to work with. So. And so maybe this is an issue of culture. Let's maybe open it up, because I know we have some government lawyers who might also like to ask some pointed questions of our requesters here, and also offer some sort of questions that could help guide us a little bit. So do we have questions for our distinguished panelists?
From government lawyers first, please. Joking.
Yeah, so we'll take it from whomever. So yes.
Hi, yes. First of all, thank you for being here today. So we touched a little bit on what agencies might be difficult to work with, but obviously the entire panel has seen their fair share of time in court. Have you found that any circuits are particularly easier on FOIA plaintiffs, or if there are circuits that are, say, I guess, more in favor of government defendants in FOIA actions? I know, as Mr. McCraw has said, Florida, who has strong state actions, would you say that the 11th Circuit, I guess, would be more sensitive to your cause?
My sense is that it's hard to say, because the FOIA requests tend to pool in three places: the D.C. Circuit, the Second Circuit, and the Ninth Circuit, because of California. And there's less law out there in other places. I prefer the Second Circuit. I think that the D.C. Circuit has seen too many cases that are brought by individuals who, and nothing against individual litigants, nothing against pro se litigants, but they tend to get short shrift and they don't make great arguments sometimes, and you get bad decisions. The Second Circuit, it tends to be more the publications, the public interest group in large numbers and so forth. So I prefer that. I have one case in D.C., but that's for strategic reasons. The Ninth Circuit, you get some pretty good results, but you get results all over the place, as you always do in the Ninth Circuit.
Yes, backward.
I'm no government attorney, just say that outright, but I will play devil's advocate here a little bit, because one of the comments that Mr. Leopold made was that with regard to the Hillary Clinton emails, you really had no idea why you might be making a request, but you made it anyway. And as to an earlier graphic that one of the presenters put up on the screen, there was a screen full of requests that just automatically come. And so I'd just like to hear perhaps your perspective, if you could,
Mhm.
out of your own professional perspective for a moment, and take it from the receiving body standpoint and say, you know, these requests are coming really for no concrete reason, for no immediate reason, and what deference or acknowledgement of that would you offer or acknowledge?
Well, first, with regard to Hillary Clinton's emails, as I said, I asked for all of the emails. When I asked for it, it wasn't, I wasn't thinking like, well, is there a specific reason that I want all of the emails versus some of the emails? But I tend to ask for everything whenever I file a FOIA request. So it's not the job of the agency to say, why are you, asking for it? If your question is, that they're being bombarded with requests. I mean, the law doesn't say, the law simply says, you have to adequately describe the records that you're seeking. It doesn't say, give us a reason why you want it, what story you're going to write. That's the way the Freedom of Information Act works. And I'm absolutely very sympathetic to the FOIA officers who I too have a good relationship with and I try to communicate with regularly, because they're bombarded and because the amendments that were passed last year under the FOIA Improvement Act did not open up any additional funds to assist them with processing these requests. So I know that when my request goes, when I initially file my request, that there isn't a FOIA officer there who's looking at it and saying, this needs to be denied. We have to try to not give Jason records. That there are times when that certain agencies, if a request has what is referred to as significant media interest, it gets kicked up, to the top, and then it becomes politicized. That's not the way FOIA is supposed to work. It's supposed to be, you describe the records you're seeking, and they're supposed to release it. So even if I didn't know why I was asking for all of the emails, that's not an issue for the government. The fact is that I can do it. You can do it. Anyone can ask for anything that they want. They certainly don't have to turn it over. You don't seem satisfied with my answer.
Fair enough. Could I speak to that?
Sure.
It seems to me, I'm not in the government and I'm not a lawyer, but if there are agencies that have backlogs, it would be good if Congress would give more funding to the agencies to deal with those backlogs. As to the legitimacy of request, I just want to talk about my own case. I've been seeking 35 documents from the CIA for over a decade now. And yeah, I've talked on the phone to an information officer at the CIA, and he's very nice, and he's very polite, but even he sounds embarrassed. I'm seeking documents that are over a half a century old. They have to do with the interactions between leaders of the CIA and certain congressional leaders and leaders of CIA and the Kennedy White House. And I'm trying to get at whether or not the CIA was responsive to direction from the president and members of Congress. This is important stuff, and I can think of no reason to keep these things secret beyond a half a century. I mean, it is beyond a half a century, and yet, it would be nice to know whether CIA was following the law or not.
So, Margaret, I saw you had your hand up, and then Alina.
Yeah, so the journalists on this panel, you all are exceptional, right? In the sense that most journalists are not using the law at this volume, as each of you mentioned. We're certainly fighting in court at this volume. And I was wondering if either of you would be willing to speak to, and in particular, David, I guess, working with lots of reporters at the New York Times, I'm sure some of them are using the law a lot and some of them aren't. What's making
Yeah, I mean, the thing that makes people successful is persistence. You know, that you can't just throw in the FOIA request and wait for something to happen. You have to treat it like reporting. I think that much of this, that those people are using a lot are going after documents that should be public, and there's not going to be a real fight over exemptions. They should be public. So many of them are dealing with regulatory, the people are using, have a lot of people are doing regulatory change as opposed to covering defense or national security where you expect there to be some pushback. And I just respond to the earlier question because I think it's a good one, is that, you know, there's no question that the agencies sometimes get swamped with these requests, and I guess part of the two things I'd say to that is that, you know, we live in a time when you can make materials available so easily. And so you see in some cities around the United States that they are using these, you know, what it's called, you know, post-FOIA, the post-FOIA world. They're pushing out the records. They're putting them online without a request. And they would do themselves such a favor if they would do that. Not, you know, wait for the request. I understand it's not for everything, but there's so much they can put out online. And the other thing is that I do find it troubling that whether you think that 20 days is enough time or not for an agency to respond, that's what Congress said. Congress said it. When Congress said I have to file my taxes by April 15th, I think that's unreasonable. They do not give me the opportunity to say, I'll get to it someday. But that's what the agencies are doing. And if courts would have said, Congress said 20 days, they meant it, either you get, so agencies get the resources to do that, or somebody convince Congress to change the law.
If I could just also add, I mean, in terms of making records available, yes, certainly agencies can do that. Right now, or at least throughout the course of this year, there have been agencies pulling down records that have been available on their FOIA reading rooms for whatever reason, which only leads to more FOIA requests to find out why they've been pulling down those records. So, I mean, it's you know, there's many steps that are being taken again to, you know, to conceal information.
Director Simo?
So I feel the obligation to not just play devil's advocate, but just share my experiences because I'm in a unique position. Having been at the FBI for almost 15 years, I was the director of the FOIA litigation unit that I actually
Feel
stood up
terrible now.
myself. So I'm not going to sound defensive. I'm going to give you a little bit of the other side of the story, if you will. I just feel like it's a little more balanced that way. So I came to the FBI in 1999 after having been at Maine Justice for 8.5 years, and what I quickly learned is that the FBI is in the business of gathering information and keeping it. And so that's the mentality that all FBI agents operate under. And that's a really important thing to keep in mind when I teach to FBI agents, I always used to say it's this constant tug, right? So FOIA is a disclosure statute. You're in the business of gathering information and protecting it and not releasing it until the end of time. So it's a constant tension, I just want you to understand, that goes on within the FBI about being responsive and statutorily obligated to respond to FOIA requests, and FOIA agents being very protective of the information they've gathered. So there is that, obviously, and I always want to point that out. The other point is that I think what I can share from the inside, having been there, I can't begin to tell you how many times I sat down with an FBI agent and asked him, is there really a need to protect that information? Because we're now getting sued, we're gonna have to tell the judge, tell me what the harm is in withholding that information. And don't just make it up, really tell me what the harm is, and tell me that it's not speculative, tell me that it's actually gonna happen immediately or within a reasonable amount of time, as opposed to, I think this might hurt my investigation down the road. I just want you to know, I want everyone to know, that kind of discussion goes on daily within the FBI in terms of evaluating information and making decisions about what gets released and what gets withheld. And again, I'm not trying to be defensive, I'm just being very candid about, you know, what goes on. And then, of course, we have the Department of Justice, who ultimately makes decisions about what happens once we are sued. We don't have independent litigating authority. We have to be represented by the Department of Justice. And ultimately, ultimately, we rely on them to defend us. Sometimes they'll say, we can't defend you on that exemption, you've got to drop it. So it's sometimes nicer to hear that from DOJ by the FBI agents. Makes me not the bad guy, right? Because if I told them, they wouldn't listen. So there are a lot of checks and balances in the process. It's not, sort of, we hate Jason Leopold, he's a FOIA terrorist. I can tell you, and this is just my own perspective.
Is that on the record? Can I get that on the record? Okay.
This is my own perspective. I will tell you that one of the frustrations that people do feel with frequent requesters is that they feel that frequent requesters monopolize the agency's resources to such a large extent that it takes away from the ability of other requesters who are standing in line and waiting their turn very patiently not to get access to their information. And I think that's one of the frustrations a lot of agencies face, because they're dealing with a large backlog and they're trying to serve as many people as possible. And people who are, filing a lot of requests are just getting an unfair amount of resources devoted to them. That's, I think a very shared perspective among many agencies. So anyway, that's all I have to say for now.
Thank you. So Director Simo will be joining us on a later panel. She is, just for identification, she's the Director of the Office of Government Information Services and is an important figure.
Right. And you make some really important points. I think one of the worst things that happened to reporters is when they started talking to lawyers, because so many FOIA requests I see now read like discovery requests, including but not limited to. People in the real world don't talk that way. Okay? I know all of you who will be civil litigators do, but it's a terrible way to write a FOIA. It may be a great way to write a discovery request, unless you're on the receiving end of it. It's a terrible way to write a FOIA request. And I think to some extent there should be a better dialogue with the people on the other side about what, how it looks from the government side. We at one point in a case had used the term, trying to help the government out, we had requested documents sufficient to show certain expenditures. In other words, don't send us every document about that expenditure, just something to show that it happened. And we ended up suing, and the AUSA said that term actually created more problems than saying all documents showing the expenditures, because it required discretion, and the concern on the agency side was that they would be criticized of choosing this document as opposed to those, which was not our intention. Our intention was to say, just give us one document that shows how much money was spent on this.
Can I just add one point to that? And I appreciate the comments as well. But again, I just want to note that again, this is what the language that Congress put in an agency like the FBI, which I do file a lot of requests with. They will often issue a response that says we're withholding everything under B7A, but the law says that you actually have to look at all those records and decide what can be segregated, what's segregable, and they don't do that, and that's a violation. And they continuously, no matter how many times I appeal, quoting the court, the legal language for them, it just doesn't happen. So there is not a very good relationship between the media and an agency like the FBI, largely because if I'm telling them this, they're not listening, and so it's even very difficult to get a FOIA officer at the FBI on the phone and to kind of hash this out.
So if I can be devil's advocate for a moment, there's a sense in which, suppose for the sake of argument here that the press isn't always interested in transparency itself. So there's a sense in which you go to the trouble, either academics or the press, to sue for a record, and say the agency decides, since it's going to have to turn it over to you anyway, it's going to go directly to its website and post the record, which is what they did to David Barrett with Volume 5. And so they made it available to all. And so it's almost like creating a free rider problem. So you mentioned earlier that you weren't going to sue for Hillary Clinton's emails because Mike Bekesha and Jason Leopold were already doing it for you, and you were going to get those records. Is this a good proposal, or is this this release to one, release to all provision? Is this going to dissuade the Fourth Estate from making necessary requests? Because there's a sense in which you want a certain amount of secrecy. Like, give me 3 weeks lead time on the competitors.
I think we're out of time.
Great panel.
This is a very awkward thing, and I think there are some major news organizations whose names will go unspoken here that have suggested to various government agencies that there should be lead time. And I can justify that. You know, we invested in the request, we invested in litigation, and so forth, and that is after these documents have been held illegally for 7 years, is it really going to make a difference whether the government gets it in 2 days or 5 days or 10 days? At this point, why not reward the requester, encourage the requesters to make the request? But it's a very difficult argument. You know, you really look like you're on the wrong side of transparency when you're saying they're mine and I will release them when, you know, just you essentially are mimicking the government. You know.
If I could just add to that, I mean, certainly, you know, as a journalist, love having scoops. And I looked at this whole idea of release one to release to all. I personally, you know, think that the proposal of that was essentially a way to thwart the many lawsuits. That's maybe, you know, my conspiratorial mind working. But I also happen to use FOIA Online. FOIA Online is the online portal where you can file requests and documents are released there. So for example, if I wanted to see things about documents that were released by the EPA or other government agencies, say that aren't the CIA or the FBI, documents have already been released there. They're, in fact, if you file a request, they're made available immediately. So the thing is that if they are made available, release one to release to all, many people won't even know about it. Many other journalists won't know about it. You literally have to go to these portals, to these websites, to find it. And you know, the CIA posts documents on their website. They don't put out a press release saying, "Hey, everyone, look what we did." Nor does the Justice Department. The FBI has their Vault Twitter account that, you know, that they will tweet about. But again, you're talking to a very, very small audience. So I actually don't feel that releasing one, release to all will, you know, you will lose anything other than, you know, maybe you can't say on your story scoop or exclusive. You could still say that, you know, your request was you know, the vehicle again that, you know, that perhaps released the records, but I actually don't feel that it would, you know, have any real impact at all.
Well, I'd like to
And I also should note that I also don't think that it will ever happen because it's the government that's working on it and it's just never going to happen.
All right. Well, I'd like to thank our panelists. I appreciate their coming to Villanova Law School. We're pleased to have you today. Thank you so much.